What's up everyone, it's a Law School Lumberjack here again with another installment of our Contracts Law 101 series. Now I know that some of my viewers are first year law students and sometimes contract law can be difficult because it's hard to figure out what the end result of a lot of contract law cases are. So today what we're going to do is we're going to go through a brief run through of the remedies that happens during a breach of contracts case. I note that this video is intended to be a brief summary or introduction to the type of remedies that can occur during a contract law exam or in contracts law cases. In future videos, we'll go into a deeper dive on damages. As well, in future videos, we will go through some of the equitable remedies available when there is a breach of contracts case or in the contracts law area. The general rule is that a breach of contract leads to damages. But in this video today, in addition to speaking briefly about damages, I will discuss two exceptions to that rule. The equitable remedy that allows one to rescind a contract or get out of a contract, and secondly, the equitable remedy of specific performance. So let's begin with the basic introduction. So the basic rule with contract law is that unlike with other areas of the law where breaching something or not following the rules might be considered wrong, contract law you have freedom to breach the contract so long as you compensate the other party for that breach. Now there's always going to be exceptions to that rule, but generally that's the sort of underpinning on which contract law is built. And what that kind of shows itself as is damages. So presumptively, what a party is entitled to if a contract is breached is damages. So the damages are intended to put someone in the position they would be in had the contract been fulfilled. So for example, let's say a situation where you agree to buy a vehicle and the other party at the last minute states that they aren't going to sell you the vehicle anymore, even though you had a firm and binding contract. And let's say you were going to buy that vehicle for $25,000. So if you have to shop around and you are able to find the same vehicle for $30,000, then to put you in the situation you would have been in had you bought the vehicle from the initial seller, you would arguably be entitled to damages in the amount of $5,000, being the $30,000 you paid less the $25,000. Now that's the basic rule, but I wish it was that simple. As in many areas of law school, there's always exceptions to the rule. So the first question is whether or not you can rescind the contract. And what rescinding the contract means is essentially you either don't close or you try and get the contract torn up. The contract is essentially found to be unenforceable. So the general rule as to whether or not rescindment is available or being able to rescind the contract is available is among two things. One, did you act in good faith? And let's assume the answer is yes. And the second question becomes, how material was the breach of contract? So the more material the breach of the contract is, or the more the breach gets to the heart of the contract, the more likely the court's going to side with the equitable remedy of rescission. And what I mean by that is this. Let's say you have an agreement to buy the car for $25,000. One of the representations, or arguably maybe a covenant in the contract, is that the vehicle will be clean, or that the seller will clean the vehicle before selling it to you. And the day of closing comes, you go to buy the car, and the car is filthy. Well, in that circumstance, arguably, the breach doesn't get to the heart of the contract. You've still got the car, it's just not as clean as you would like. So as a result, you'd arguably have to close the deal, pay the $25,000, get the car detailed, and sue for the cost of detailing the car. In that case, it's likely that you'd be stuck with the general rule, meaning that you are stuck with damages. However, we can imagine another situation where you agree to purchase a car for $25,000 and the person shows up with a bicycle. Well, obviously in that circumstance, it's arguable that, or very arguable, that the lack of the car and the fact that the party gave you a bicycle suggests that that goes to the heart of the contract. And it's much more clear that that one, or that fact scenario, would likely lead to a case where you'd be able to rescind the contract. So I've given you kind of the two goalposts, clearly not rescindable, clearly rescindable, but on a law school exam, you'll probably end up with something in between those goalposts. So you might have a situation where, there's a question of whether the car is in good working order. Let's say a party represents that the car is in good working order, and you get the car and halfway down the block it breaks down. The question becomes, are you able to rescind that contract? And what you want to do is really consider if damages would be able to make the person whole again, or if the breach is so central to the contract that damages wouldn't be able to suffice, and it's in the best interest or the interest of justice that the contract be held to be unenforceable. So let's go back to the original example where the seller refuses to close and refuses to sell the car to the buyer. The general rule is that one has to mitigate damages by buying the other car or buying a similar car and then suing the seller for the damages for not closing or for breaching the contract. Now, there is one exception to that, among others, but the one I will talk about today is specific performance. Again, I will go into a bit more detail about the equitable remedies and specific performance in a future video, but the general rule is that with specific performance, you give up the right to damages, but you can then force the buyer to close or to follow the terms of the contract through the courts. There are some requirements for specific performance, just very briefly, and those are, firstly, again, that you have to act in good faith. So you can't, the buyer who's seeking specific performance can't come in with what's called unclean hands or do something that's wrong or untoward. The second aspect is that damages will be unable to make the buyer whole. And to prove that, what the buyer essentially has to prove is that there is something special about that item that they're trying to buy, such that they can't find a similar substitute. So you can have a situation, for example, I can think of two examples where it's arguable that specific performance may be possible. Number one, let's say that vehicle was one of a kind. Let's say there was only one made. Let's say it was made by a famous designer. Then one might be able to argue that that might be a situation where specific performance is warranted. You can then imagine the converse where you were just buying a simple vehicle, like a simple sedan, that you could purchase anywhere on Auto Trader or Craigslist. Well, clearly that would be a situation where specific performance may not be possible. The other example might be a situation where there is some sentimental value associated with the item. Let's say you had a situation where you were searching high and low for your deceased grandfather's vehicle, let's say, and you finally found it. That might be a situation where you might be able to argue that there is a claim for specific performance because that vehicle and the sentimental value associated with that vehicle is one of a kind. Again, these are just ideas that may show up on your law school exam, and hopefully this video is showing you what happens when a contract is breached, what the general rule is, and some exceptions that may be available should you be writing the law school exam. I hope this video was helpful. If it was, please like and subscribe. Thank you very much. Take care. Have a good evening.